Welcome to New Horizons. I'm Suzanne Barnett, your host. Tonight, I am so pleased to introduce my guest, Lisa DewBerry, who is a criminal law specialist. In other words, she's a lawyer, and a very, very good one. And Lisa is a criminal law specialist certified by the California State Bar Association. I'm going to wait and tell all the rest of it later.
Okay.
Lisa, I'm so happy you're here.
Well, thank you for having me.
I really am. And you've tried over 125 cases?
Yes, I have.
Including adult and youth.
Right.
Yeah.
Yeah.
How is that for you?
I enjoy what I do. I enjoy working with my clients, working with the courts, and with my colleagues and the prosecutors. There is certainly, every day when you go to work, there's always a new story, so nothing ever gets dull.
And I was asking you before, are you really just absolutely crazy about your job?
I do. I love it. When I was in law school, I did not even think about criminal defense as a career. And once I got out of law school and I was looking for jobs, interviewing with law firms and Big 8 accounting firms, I realized that that was not the path for me. A friend of mine who's now a judge was working for the public defender in San Francisco and suggested that I apply for a job. So I called Jeff Brown and Peter Keene and asked for an interview. I was told, well, we don't have any jobs available. I said, well, I'd like to come down for an informational interview anyway. So when I came down, my future supervisor was walking out of Peter Keene's office when I walked in, and I got a job in 10 minutes because Peter needed somebody right then and there. And I thought, well, this will be a job for a couple of years, and then I just fell in love with it. And I stayed in the public defender's office for 23 years. 23 years? Yes, I loved it.
And now you have your own law firm.
Right. I've been in private practice going on 9 years now.
And how is that?
I love it. When you work for a large entity like the public defender's office in San Francisco or any large firm, you've got to do things the way your superiors want you to do them.
Of course.
It's their reputation on the line, and so you do it the way they want you to do it. But now that I'm in private practice and I work for myself, I am able to bring my spin, and I enjoy that as well.
Well, you have done so many high-profile cases, and I'm going to ask you a question that's everybody, I'm speaking for the public. What happens when you have a client that he may be or she may be a sociopath, a narcissist, psychopath, and they're really not telling you the truth? And how do you work with these people?
Well, a lot of people ask me the question, how do you represent guilty people?
Yeah.
And when you know that they're guilty.
Yeah.
And my job isn't to decide whether or not they're guilty or innocent. That is the job of a jury if we get that far. But to answer your question about working with people who have what they call access to diagnosis, people who are sociopaths and narcissists, have social issues, it's important for them to understand what the process is. So I spend a lot of time explaining what the charges are, what the next steps are, and I try to develop trust with that person. Whatever a client tells me happened is what I have to work with. There are some ethical rules that I cannot knowingly present false information. But, if I don't have information to show that what they're saying is false, we have to go with it. Of course, I try to have people understand what the process is and have them adopt what is the truth so that we can go forward. I don't think it does anybody any good to lie to their lawyer.
Yeah, yeah. But do they know that, Lisa?
Well, some people do and some people don't.
Yeah,
I mean, it's an individual case by case.
So when you have these very, very difficult, heavy-duty cases, what do you do? Do you take those home with you? Are you able to relax away from them?
It's really important. I've been an attorney for almost 32 years. Mm-hmm. And it's one thing that I've learned is that there has to be professionalism. There's got to be a bright line of professionalism between you and your client. I've seen attorneys over the years get emotionally, sometimes personally involved with their clients, and it doesn't do anybody any good. It makes the lawyer less effective. It exposes the clients to all sorts of bad things, not just with their case, but with their private lives. So there really needs to be a very bright line between the client and the lawyer. I do my best not to bring things home. Of course, you're going to have situations like in any job where you're going to bring home an issue and you'll fret over it. But for the most part, my clients, I treat in a professional manner and they stay in the office. I come home and I spend time with my husband and my dogs.
And we have this perfect time. Your husband is the director of this show and many other shows.
Yes, and he's also, I have to say, it's been a great help to me in my practice because he's also a software engineer and has helped me put together presentations for trial. So he's been great to work with.
You're like partners.
We are.
Yeah.
We are.
Partners in crime, but not really. Right. Another personal aside is that I asked you, when you were a kid, did you ever consider being a lawyer?
Yes. When I was a little girl, Perry Mason was on its first run. Not a rerun, it was on the first run. And my sister, who is an attorney also, she and I used to watch Perry Mason, and we would object. We were like 5 and 6. We would object, and we would wait for the court's ruling on television. So yeah, both of us always wanted to be lawyers.
And your sister also is a lawyer.
Yes, she is.
The other thing I wanted to say, you have some very pertinent questions. What is it like to be accused and going through the adult criminal system, the juvenile delinquency system also?
So there are two different systems altogether.
Right.
And let me talk a little bit about the adult system. When someone is accused of a crime, obviously they've been arrested. They've been booked, which means to be brought down to the police station, arrested, having their photographs taken, and then put into the county jail. Bail is set. I'm talking about felonies, misdemeanors also, but let's concentrate on felonies. And just so the audience knows the difference between a felony and a misdemeanor is, with a felony, a person could go spend more than a year in the county jail or in state prison. With a misdemeanor, it's up to a year in the county jail. Okay, so bail is set according to a schedule that each county figures out for themselves. And they have to, in order to get out of custody before going to court, that person has to make bail, which is put up a large sum of money, sometimes in the tens of thousands, sometimes in the hundreds of thousands of dollars, or they have to go to a bail bondsman and put up 10% of the bail plus collateral in order to get out of custody. The next step for them is that the district attorney will review the police reports and file a complaint most times with the court. The other route is that the district attorney can decide to indict, but that's another process. When the person then comes to court on arraignment day, They're advised of what the formal charges are in that complaint, and then the matter is then set for a preliminary hearing to see if there's enough evidence to make the person stand trial. And then thereafter, the matters are set for trial. Of course, there's a lot of stuff that goes on in between, but those are the major steps. And that process is very terrifying for most people. You can imagine you're arrested, and let's say you may have done something wrong, but it isn't as bad as the victim claims it is, or maybe you're entirely innocent, and you expect to have the police pay attention to what you're saying. But that's not the police officer's role. The police officers are there to keep the peace, and if there is a complaint made, if it sounds credible, then they're going to arrest, all right? So their decision is to take it to the district attorney. The district attorney is the next decision maker, and that same defendant thinks, well, gee, the district attorney, if I can just talk to that person, will understand my side. Well, they don't understand that the district attorney doesn't talk to the accused. At best, they'll talk to the accused lawyer. And then we go to the next decision maker, which is the court, the judge, who reads the complaint and advises the defendant on what is going to, the charges are. And the defendant again thinks, well, if I could just talk to the judge then. And it's a very frustrating process for most people because there is a definite path that we have to go down. And they won't be able to tell their story when they want to tell it. And it's very frustrating for them.
What about the juvenile?
With the juvenile system, we use a different type of language altogether. We don't talk about complaints, we talk about petitions, right? We don't talk about guilty pleas, we talk about admissions. We don't, juveniles don't have a right to a jury trial, they have a right to a court trial. And that's all because theoretically, juveniles are not convicted of crimes. Juveniles don't commit crimes, they commit offenses. That has changed a lot over the last 14 or 15 years, where we're seeing more and more children being charged as adults or having their prior adjudications used as criminal convictions. So that's changing.
Very, very well explained. What does a person have the right to expect from court-appointed counsel and then, or from, like you, privately retained counsel?
Okay. I do court-appointed work and private work.
Both, okay.
And both sets of people have a right to the same thing. They have a right to know that their attorney has received all of the information about their case and will continue to investigate the case with an investigator if necessary to make sure that they have what we call discovery, which is all of the information that the prosecutor must provide, okay? So they have a right to know that that attorney is going to be well-versed in their case, well-versed in what the law is relating to their case, and they also have a right to know that this lawyer is going to be well prepared to present their case before a judge at a preliminary hearing or at a trial. Clients think that because one attorney might have a prior experience as being a prosecutor or a police officer or may know a judge, that somehow that is going to get them some extra attention. It actually does not, because if the judge has a personal relationship with an attorney, it may be that the judge may have to recuse themselves to get out of the case. Clients don't have a right to expect a particular outcome in advance. In other words, if you were to come to me, Suzanne, and you could say to me, Lisa, if you pay me $50,000, can you guarantee that I'll get off? I cannot tell you that, I can't make that promise to you.
What about $100,000?
Not any amount of money. No amount of money.
Yeah.
Can I tell you, you will definitely get off. I can give you my best estimate of what will happen based on my prior experience, based on the facts of the case, what I think may happen, but I can't guarantee anything to you.
Of course not. And that must be very difficult for the client.
Well, it's difficult for the client, and it's difficult, with juveniles, it's difficult for the parents of the kid who is being prosecuted. Because those parents, of course, now have no control over their child. Now their child is in the hands of an attorney, the DA, and the court, and the probation department, and they have very little control over what happens. In fact, in juvenile cases, parents want to tell me how to run a case, or they insist on knowing what a child has said to me. I can't tell them. Just like with an adult, whatever a child says to me is confidential.
What are the long-term consequences of a criminal prosecution?
Well, there are many. Let's say you're a young man and you're 18 years old, excuse me, and you've been charged with drugs, okay? But it's always been your goal to be a Marine. You go through the case, and in some counties, or let's say you can't get anything other than a conviction, either because you've gone to trial and you've been found guilty, or the nature of the charges are such that there isn't an alternative other than a guilty plea. Well, you've just lost your opportunity to go in the Marines. The Marines will not take you. Maybe the Army might take you, the Navy might take you, but the Marines definitely, that's over. It may have consequences as far as you getting funding for school. You'll have a conviction on your record, so if you are going looking for employment and you're just as qualified as someone who doesn't have a record, they're going to take the person who doesn't have a record. All right?
Can the felony ever be erased once you've had a felony?
You can have, depending on, in most circumstances, the answer is yes. As long as you're placed on probation, or if you do straight time in the county jail. But if you're sentenced to prison, you cannot have the matter dismissed. You would need to get a commutation or a pardon from the governor.
Boy, I sure don't want to commit a crime after talking to you, honey.
It's very painful.
What is it like for an attorney who knows, but that's the question that I first asked you. This is very good. What are the beliefs or misconceptions people have about the criminal justice system, like the role of police officers as deciders, you kind of talked that, role of prosecutors as deciders, and reasons why all accused, innocents or culprits, should exercise their right to remain silent during questioning? I think that's a very important question, Lisa.
Right. Well, what you talked about before was, police officers decide what their role is in their decision-making process. They're there to gather information. I have had many cases where, particularly when we're talking about juveniles, I can just go down and talk to the police and they'll understand my kid didn't do anything wrong, that other kid comes from a terrible family, so on and so forth. And what parents don't seem to understand is a police officer is an information gatherer. That's his main job. And if the evidence is credible and not inherently incredible, he's going to pass this off to another decision maker, be it a district attorney or the probation department. And all the information that the family gave, parents don't have a right of confidentiality. They can be forced to testify against their children.
Really?
Okay, and yeah, there's nothing in any code that says a parent can't be called to testify against their own child, right? There are specific codes with regard to marital privileges, but there's no parent-child privilege. And also, if that parent brings their children down, you talk to the police, tell them what happened, right? The child has now waived his right to remain silent, and whatever he said it can be used against him in the court of law, the Miranda warning, right?
Yeah.
So it's very important that people understand that. Even if you are doing everything you can to be helpful, you can say something the wrong way or not present your case as well as an attorney could, and all of a sudden you find your case getting larger and more ominous because you didn't stand on your right to remain silent. It's really not a technicality. It's a constitutional right, and it's there for a reason.
Well, one of the last questions, and then I'm going to ask you something personal. That'll be the conclusion. But I really would like you to talk about this. The juror's role. What are they getting themselves into, and why did the attorney reject me? You know, like some people don't, most people I don't think want to be jurors, but say they do, and the attorney rejects them. What about that?
Well, when I select a jury, I'm looking for people who can be as fair as humanly possible. We all come to the courtroom with our own mindsets, our own prejudices, and our own feelings about things, okay? But depending on the kind of case it is, you might be better for this case as opposed to something else. I tried a murder case about a year ago. My client was accused of, after a high-speed chase, running into and killing a police officer. And of course, you know, the prosecutor wanted people that were going to be favorable to the prosecution, and I wanted people who were going to be favorable to the defense. Well, neither one of us should have what we want. Mm-hmm. What we really are looking for are people who can be fair, people who can set whatever their life experiences are and set them aside so that they can hear the case. So when we reject you or reject a person, it's either because the juror has self-selected themselves and said, you know, I can't be fair in this particular case, or they have a lot of life experience that is just going to color how they view the world, and they are probably not the right person for that case. That doesn't mean that they're bad people or that they're bad for another case. It's just that this particular case is not the one for them.
But isn't that so difficult to find a juror that's so-called, you know, in the middle range, that doesn't have these prejudices and so forth, Lisa?
Well, no, it's really not.
Really?
It's really not that difficult. We use jury questionnaires, and the one that I was telling you about, there were like 75 questions. It was a long questionnaire. The case took several months to try. So we wanted to make sure that if there was any inkling, any advanced information from newspapers, anything like that, we wanted to know about it. And, you know, to really question those people and let them know just how important it was. I mean, you want a fair jury if you were accused of something. And I think that jurors want to be fair. Everybody wants to be fair.
Oh, yeah.
And so they were very gracious about it. They understood the process. And like I said, a lot of them self-selected themselves out of the process.
They did, yeah. We only have a few more minutes, but you offer a unique perspective on what society can do to improve the lives of children and adults enmeshed in the criminal justice system. You have to say it in about 3 minutes.
Okay.
Can you do it?
Oh, well, I think we need to roll back this penchant of ours to treat juveniles as adults. They're not adults. Their brains have not fully formed. I've heard the argument, well, they do adult crimes, they should pay for adult crime with the same kind of time. But, you know, they're kids. And we're talking often about kids who are coming from families that are split apart, parents who are working all the time, or parents who, for whatever reason, are absent, and these kids are left on their own. I think we need to roll back. We need to start thinking about, gee, we shouldn't be using these prior these prior adjudications as strikes against kids when they turn 18. We need to spend more time and more money on education and after-school programs and work programs for kids rather than just prosecuting them and locking them up.
Lisa, you have been such a wonderful, awesome, fabulous guest. And I mean, I thought I knew a lot about the law because my husband, you know, was a Superior Court judge. But your information has been so important. And I thank you so much. And I hope you just keep having the hottest cases in the world. But it has to be California, right?
Absolutely.
Yeah.
Thank you very much for having me.
Oh, you are terrific. God knows if I have a criminal thing, I'm coming to you, Lisa.
Oh, thank you.
And I want to thank our crew. And imagine Tom Clark, the hot director, having his wonderful wife on the show. And the rest of the crew is also wonderful and talented. And I also want to thank our audience for watching. What would we do without our audience? And I cannot wait to see you next time. Bye-bye. Lisa, you were